Hello, our topic today is personal status theory. Let us introduce. We are from Group 5, consists of Sovina, Marthalia Setiawan, and Yohannes DS Sitorus.
Personal status is the state of a person under the law that is given or recognized by the state to protect his rights. This personal status includes the rights and obligations of the ability and inability to act in the field of law, the elements of which cannot be changed at the will of the owner. To determine one's personal status, the countries of the world adhere to two principles: 1. Nationality principle. 2. Residence law. 1. Nationality principle, that is, the personnel status of persons, both citizens and foreigners, is determined by their national laws. The principle of nationality is permanent because it is not easily changed like residence law. Examples of countries that adhere to the principle of nationality: China, Japan, Mexico, and etc. 2. Residence law is a legal relationship that is accompanied by certain political characteristics that are built between people and certain domains of government, where most of that person's important business takes place in that place. There are three main principles ruling over residence. First of all, every person should have a residence. Second, no individual is allowed to have more than one residence. And third, residence is not permanent. Example: Brazil, Peru, Guatemala. Indonesia adheres to the principle of nationality or residence law. Indonesia adheres to the principle of nationality, so that all countries residing abroad, as long as their personal status is concerned, must comply with Indonesian national law. Based on Article 16ab, personnel status and authority of a person must be assessed according to their national law, lex patriae. Based on jurisprudence, the principle of nationality also applies to foreigners residing in Indonesia, and their national laws will be applied to regulate their personal status. Case related to the personal status theory.
This case is a fight between Jonathan Ikine against Purnima Ralhan based on the decision number 394, Pdt.P. 2007 per Pdt.P.Jak.Sel. This case is considered as private international law case because this involves two foreigners who got married in Philadelphia and then domiciled in Indonesia. Domestic violence by Jonathan ended in divorce in Indonesian courts based on their domicile. Philadelphia adheres to the bona fide residence where divorce can be filed if you are domiciled for 6 months. In Article 16 of Law 4 2004 about judicial power, that courts in Indonesia are obliged to accept the lawsuit filed. The chronology of this case begins when Jonathan Ikine proposed and married Purnima Ralhan on the 23rd of May 1997 in Philadelphia.
Purnima, will you marry me?
Yes, I would.
In 2000, the couple moved to Indonesia and domiciled in Jakarta. On December 24, 2001, a baby girl was born from Jonathan Ikine and Purnima Ralhan.
Oh, our baby.
We name our child Lara Rose.
Congratulations.
5 years have passed. Jonathan and his family are living happily. However, in 2007, Jonathan started physically and mentally domestic violence against Purnima Ralhan and Lara Rose.
I'll kill you.
No. Please don't hurt us.
Violence continued. Purnima and her daughter left Jonathan's house on August 19, 2007. Purnima Ralhan goes to her parents' house and complains about Jonathan's actions against her and her daughter.
Mom, Dad, help us.
How dare he hurt my daughter and granddaughter.
We have to report his actions.
On September 23, 2007, Purnima Ralhan finally reported her husband's domestic violence through the police station to get temporary protection under Article 16 of the Domestic Violence Law. By providing temporary protection from the police, Purnima Ralhan then went to the South Jakarta District Court to apply for a protection order and file a lawsuit against Jonathan Ikine.
I want to file a lawsuit against my husband and protection for my family.
Okay, ma'am. Calm down first. I will follow up on this request.
Jonathan Ikine then received a lawsuit from the court with the contents of the lawsuit in the form of divorce, transfer of child custody, and protection of the plaintiff, child, and plaintiff's parents. Disagree with that, Jonathan immediately contacted his lawyer.
Hello, Mr. Silviani. Oh, Sir Jonathan, long time no see. Can I help you? Yes, I got a lawsuit from my wife and I need your help to defend me as my lawyer. Alright, let's talk more in my office. Okay, thank you, Mr. Silviani.
So what is the legal issue in this case? The legal issues in this case are divorce and child custody.
The trial of the South Jakarta District Court No. 394/Pdt.P/2007/PN.Jak.Sel is declared open and open to the public. To the plaintiff, please submit your lawsuit.
All right, Honorable Judge, we file a lawsuit against Jonathan Ikine for his domestic violence with the contents of the lawsuit in the form of divorce, transfer of children's rights, and protection of the plaintiff, child, and plaintiff's parents. We also request to grant custody of the child to the plaintiff and determine the status of property in both Indonesia and a house in Philadelphia to be in the name of the plaintiff.
We reject the lawsuit because the Indonesian court is not authorized to hear this case where this couple has not registered their marriage at the Civil Registry Office and only has a marriage certificate from Philadelphia.
The plaintiff cannot file for divorce in his home country because in Philadelphia adheres to the principle of bona fide residence, which requires the parties to stay for 6 months before the divorce occurs, so that this is impossible for the parties to do because the defendant's actions can endanger the plaintiff and her daughter.
However, the Honorable Judge, if the claim for divorce is granted, many foreigners will get divorced in Indonesian courts, especially for the sake of smuggling the law. So that the Indonesian courts should not seek solutions or impose laws on the grounds that the plaintiff cannot file a lawsuit in another country.
After hearing the parties, the panel of judges considered that, 1. Because the plaintiff who argues that it is no longer possible to pursue a lawsuit in his country of origin, this case can be examined. 2. To apply the case for divorce of foreign nationals and child custody based on Indonesian law. 3. In a short time the couple cannot solve the problem if they have to return to the United States first and collide with the bona fide resident principle. With this, the panel of judges will prepare a decision and will be read out on January 21, 2008. Trial closed. The agenda for today's hearing is the reading of Decision No. 394/Pdt.P/2007/PN.Jak.Sel on January 21, 2008. The verdict is as follows. 1. Completely granted the plaintiff's request. 2. Provided a protection order for the plaintiff and the plaintiff's child and the plaintiff's family. 3. Declared to revoke the defendant's custody as the father of Lara Rose. 4. Ordered that the child be placed in the sole protection and care of the plaintiff and or the plaintiff's parents. 5. Ordered the Indonesian National Police and or other authorized agencies to provide temporary protection for the plaintiff's child. 6. Ordered the child's residence permit to be transferred from the defendant to the plaintiff as the child's custodian. 7. Determined that every time the defendant wants to meet Lara Rose, he must confirm in writing to the plaintiff as the custodian and or joint supervision of the plaintiff's parents.
This case is in line with our topic of personal status theory, which discusses the state of a person under the law given or recognized by the state to protect her rights. In determining personal status, there are two principles, namely the principle of nationality and residence law. This case is based on the law of residence, i.e. the place of residence, and most of the important business of the person takes place in the country. So in this case the plaintiff exercises his rights as a foreign citizen who has been domiciled in Indonesia for a long time with his family. So that the residence law can apply, and the panel of judges in the state of Indonesia has the right to give a decision on the lawsuit filed by the plaintiff, even though in the case of divorce there is a rejection as a result of the non-registration of the marriage of the two foreigners in Indonesia, but the lawsuit against the transfer of custody of their child has been won by the plaintiff, even if it is temporary.
Thank you to our lecturer of private international law, Miss Ninne Zahara Silviani, has provided knowledge that is very useful for us.